Hello, good afternoon, everyone. Thank you for joining us. Welcome to the 10 biggest legal mistakes business owners make. So I'm just going to give everyone just a couple more minutes before we get started to enter the room. And again, thank you so much for joining us. I'm going to put our contact information in the chat so that everyone has it. I'll be just a moment before we get started. All right, everyone. Thank you for joining us. Okay, we are going to get started. Thank you so much for joining the SBA 7J Lunchtime Learn, and welcome to the 10 biggest legal mistakes business owners make. So what I'm going to do is I'm just going to go over a little bit of housekeeping so that everyone knows how GoToWebinar works, and then we'll get started. Okay, so I want everyone to take a look at your control panel. So this will help you navigate during this process. So you've got your orange arrow, which should pop out your control panel. Everyone is muted, so I can't hear you, I can't see you, none of that. So if you have any questions, if you have any comments, please add them to your questions or your chats tab. Some of you, it is merged together, others have chat and questions. So please, any questions, comments, please add it to your chat or questions tab. If you have any questions, you're welcome to raise your hand, but please put all your questions and comments in the chat or the questions tab, because I will get as many of those questions answered for you during this presentation. You can toggle there to see other attendees, and that's it. It's pretty easy and straightforward. Now, a little bit about the SBA 7J Management and Technical Assistance Program. The SBA 7J Management and Technical Assistance Program is geared towards helping small businesses become government contract ready. We do one-on-one, excuse me. Well, right now we don't do in-person training, but we do one-on-one training virtually, and there's lots of online training. Please go to smallbusinessassistance.com, register on the site. You'll be able to see all the past trainings that we've ever done. I think the website may be up to about 30 trainings. They're set up in a classroom format, so once you say you leave in the middle of your webinar, you can always go back and take a look at it again. And please email me. There's my email address if you have any questions, any comments. So my goal is to help you guys become government contract ready. That's the goal of this whole program. Now, a little bit about our speaker, Sam Bryant from Bryant Taylor Law. He is a corporate lawyer, and Sam counsels business owners on entity formation and helps identify any legal issues that present themselves throughout a business lifecycle. He has experience in drafting, reviewing, and negotiating operating agreements, partnership agreements, non-competes, and franchise agreements. Sam also provides ongoing legal advice to businesses of all sizes to help them navigate state, national, local laws and rules and regulations. So before I turn this over to Sam, in the chat section or in your question section, whichever one you have, please put the kind of business that you do. Do you own a retail operation? Are you in construction? Do you have a service-oriented business, or do you have a goods-oriented business? So please put that in the chat. We'd love to hear from you. And while you add that, I am going to give Sam the control and hand it over to him, and we will get started.
Thank you, Allison.
You're welcome.
Share
All
my
right, Sam,
screen.
you're good to go.
All right, can you see my screen?
I can see your screen.
All right, perfect. So I'm just getting this. Allison, just so you know, the chat box, I'm gonna have to minimize this to see my presentation. So if there's any questions, anybody, if you want to put it in the chat, I'm happy to answer them throughout the presentation. Allison, I just won't be able to see them as I'm going. So if you don't mind, if you could just let me know when there's a question.
Yeah, I can handle that for you. Well,
Perfect.
let's see. People chiming in. HR for small businesses, does service for construction requirements, planning and construction services, construction, quite a few construction people in here.
Okay.
Accounting services, service-oriented consulting for data science. We have a psychologist that used to be an accountant. Lots of construction. Yeah, thank you all for joining us and thank you for sharing.
Yeah, and it looks like there's a lot of service-oriented businesses. You know, in my line of work, I do cater to both product and service-oriented businesses. So, I mean, with that in mind, I mean, I'll definitely give you some tips for your type of business, because as a service-oriented business or for product-oriented businesses, there's certain mistakes that you can make and they can be prevented, but you also have certain obstacles that are unique to being that are unique to service-oriented businesses. So, well, throughout the presentation, I'll kind of touch on that so that we can kind of, so you can kind of understand that how you can navigate these issues by the very nature of your type of business. So with that said, that this whole presentation is based off of these 10 core mistakes that I've learned over the years that business owners just tend to make over and over again when they come to us for the first time. So by listening to this presentation, the hope is that you're going to be aware of these things, and at the very least, whether or not you decide to hire a lawyer or even speak to a lawyer, that you can at least be aware of mistakes that can be made, and you can put yourself in a position to prevent them in the future. So as Allison said, we are business attorneys. I do have a business partner and we have staff, and we're really focused on Florida businesses. We help them achieve financial independence and financial freedom because that's the goal of owning a business. I like to say that anyone who has a business is starting it primarily for either you want to sell it one day, you're looking for some sort of financial independence, you're looking to generate wealth, or you're just looking to establish some sort of legacy or a dynasty that's really going to make an impact on society. And these mistakes we're going to cover all get in the way of that ultimate objective. So if you can navigate and overcome these problems, these legal obstacles, then it paves the way for you to really achieve those primary objectives. Because otherwise, what's the point of even starting a business if you can't achieve those primary objectives? So in this webinar, we're going to focus on a few topics. And all these 10 mistakes are structured around these 4 topics. The first is entity structures. One of the first decisions you're going to make as a business owner is what type of entity are you going to choose? Are you going to choose an LLC, a partnership, or a corporation? So we're going to kind of discuss the differences between those type of entities and some mistakes that business owners make when they're choosing them. Then we're going to go into tax considerations. I'm not a tax attorney, so I'm not going to go heavy into the details about that. I just want you to understand in this presentation that the type of business you have, the entities that you choose, may affect the taxes that you have to end up paying. So you want to just keep those in mind, and we'll touch on those. We're going to go into contracts. Contracts are essential to doing business. I think that in an ideal world, to be able to have a handshake deal with your customers and clients, but unfortunately, you live in a world that sometimes you're going to really you're not going to feel protected unless you have something in writing. And that's mainly because you're really dealing with humans. And sometimes, even though you have the best intentions on one side or the other, there's always miscommunications, there's always expectations that change. And so contracts are central to doing business. And so we're going to really go into these mistakes that are made when you as a business are engaging with customers and using contracts. We're also going to touch on intellectual property. One of the core values or what makes a business valuable is the unique offering that you have that no one else does. It's those creations. So even if you're in a service-oriented business, there are things that you have that are unique to your business that should be protected. So we're going to go into that, the intellectual property that is available to you and how you can best protect that and what mistakes are made along the way in achieving that. So the first mistake we're going to get into is not incorporating. What many people don't know is that as a business owner, you don't have to incorporate. And that really means that if you're not incorporating, it means that you as an individual are doing business as yourself. So and it seems like we have a lot of construction businesses in this webinar today. This is very common in construction businesses. If I were laying pavement as my business, I may not actually formally incorporate. And I would maybe do business as, so I file a DBA with the state of Florida, and I would just collect money, put it in my personal bank account, but I just use the name of my business in my advertisements. That's not incorporating. That's a business mistake because you are not separating your personal assets from your business assets. One of the main benefits of having a business is that you can create a business, engage with customers, and service those customers without the risk of your personal assets being at stake if you were to get sued. So by having a business, you can engage in a risky endeavor, but be assured that your personal assets will not be at stake for anything that happens in the business. So if you're not incorporating, it means that you are doing business, but if you were to ever get sued, your personal assets could be at stake. Your house could be at stake, your bank accounts, your investments could end up being at risk as a result of an action that happens while you're doing business. So let's just say that you decide to actually form and incorporate your business. So you want to have this liability protection that incorporating gives you. Once you make that decision, you have multiple types of entities that you can choose from. And as I mentioned, you can choose from a corporation, a partnership, or an LLC. There's even subtypes of corporations and subtypes of partnerships. I'm not going to go too deep into all of them. I'm going to focus on these main four that I have here. So a C corporation, we'll start with that one. If you have a business that you're thinking is going to be the next Facebook, or a business that's going to be growing rapidly, I'm talking, from 0 to maybe $2 to $3, $4 million in maybe a year, and you're using that growth that growth is a result of investments, bringing on venture capital, then you may want to consider the C corporation. These allow you to have flexible profit sharing mechanisms, but most importantly, a lot of outside investors require you to be a C corporation if you're going to accept that investment. So if you are in this space, if you're one of the software type of companies, social media type of companies, and you choose to form an LLC, that may be an obstacle of you getting funding in the future. So let's just say you decide to be an LLC. This is one of the most common forms that people choose nowadays because it offers a flexibility in tax elections and management of your company. So the LLC is very easy to form. It allows you to be very flexible in how you run your company. And then you also get to take advantage of the tax benefits that partnerships allow. And the LLC even allows you flexibility in how you want to be taxed. So you can choose to be taxed as an S Corp, a C Corp, or a Corp, or a partnership if you are an LLC. That's why this is one of the most common choices that people use, because you get this liability protection, you get this flexibility in how you want to manage your company, and you get the tax benefits or you get the flexibility of choosing how you want to be taxed. So moving on to the S corporation. I want to emphasize that a S corporation and a C corporation are the same, or they're still corporations. The only real difference between the two are how they're taxed. So the S corporation is taxed one way, a C corporation is taxed another way. So the S corporation offers this flexibility in how you want to, in your accounting methods, mainly in that when you have an S corporation, you can set yourself up so that you can have a salary and that you can choose, as long as it's reasonable, that gets taxed. You have your payroll taxes that comes out of your salary, but you also get to set distributions that are not taxed. This setup is a very attractive option for business owners that are smaller in nature. Maybe you're by yourself, or maybe you have a few employees, and you want that ability to really limit your tax burden, but allow yourself to take money out of the business. The partnership, the only real requirement for a partnership is you have to have two owners. So this partnership, this actual business entity is not available for a single person wanting to start a business. Florida offers a lot of different types of partnerships that, again, I'm not going to go into those, but just know that a partnership, the benefit of having a partnership is that you get liability protection if, well, for one of the types of partnerships, you get liability protection if you are doing everything okay and your partner ends up doing something that ends up getting the company sued. You can be protected. Now you have to choose a specific type. That's why I'm not going to really get into them, but just know that if you have a business partner, that you may want to choose a partnership. What I will say is that the LLC is most likely in 9 out of 10 times going to be the default entity that you're going to choose. So even if you have two partners, the LLC may be a more attractive option for you because you get everything as far as liability protection the partnership gets, but you can choose to be taxed as either a partnership or a corporation. Allison, before I move to the second mistake, are there any questions?
Yes, I do have a couple of questions. Okay, Sam, can you touch on an LLC corporation that files as an S corporation so that others understand this flexibility, the pros and the cons?
Okay, perfect. So if you decide to form an LLC and you decide, and let's just say you go to a CPA and the CPA tells you that you should file as an S corporation. A CPA is probably telling you this based off of your personal income or your personal situation. In that case, you have to take another step in electing to the IRS, telling the IRS that I want to be a S corporation or I want to be a C corporation. And so when you do that, so you have to, that's the critical thing you have to do. So you can't form your LLC and then just think that I want to be a C corp or an S corporation or a C corporation. You have to actually take an extra step in notifying the IRS. The benefits of the S corporation is really that flexibility in how you can differentiate how you as an owner get paid. You can differentiate your compensation as a salary and also other compensation as a blanking, not a, you can call it dividend or draw, whatever you want to call it, but a profit split. The drawback for the S corporation, for the most part, is there's a lot more rules that the IRS imposes, because with all this flexibility, with the S corporation, there's also responsibility that you can't have partners that are not citizens of the United States. There's certain types of businesses that may not be able to get this election. You need to verify that with a CPA. But there are restrictions on the type of businesses that can actually take this election. And also for partners, you can't have more than, I think it's 100 partners. So, those are things to keep in mind. The C corporation, one of the drawbacks that I've seen from people is that it gets complicated with your accounting sometimes. So you may have to end up paying a CPA more to do your books when you have a C corporation. The dividends that get paid out if you're gonna pay out profits to partners and you have a C corporation, that gets taxed as income. So, if you like that idea about splitting your compensation between a salary and a profit split, then the implications change depending on if you're a C corporation or S corporation.
Okay, thank you for that clarity. I do have a couple more questions. One is, no, you touched on this one already. Are owners allowed to have a salary with an LLC?
And yes, so you are allowed to. The implications of that is going to depend on the tax election that you choose. But the S corporation is the one where you have to have a salary. So if the question is that can an LLC have a salary? Yes, you can. If you're an LLC that chooses the S corporation election, or you're an S corporation, you do have to have a salary. So if you don't want a salary, then you may want to look at being taxed as, if you have another partner, you may want to be chosen as a partnership, or just have the taxes pass through so that all of your income is considered, the income of the company flows through to your personal income.
Okay. And this is a question that you probably will touch on later, but can you speak about NDAs? So
yeah, so that is going to be, we will touch on that later. So I want to respect everyone's time. So for the sake of time, I'm going to try to move this along a little faster. I know I tend to elaborate, so I'm going to really try to get through this. I want you all to get the full benefit of the presentation.
Elaboration is great, but yeah, please keep going.
Okay. So the second mistake that I see people make, this is pertaining to someone who goes into business with another person, is that you don't actually have a partnership agreement in writing. The reason this is important is because what I see as a business lawyer is that when someone is starting a business with another person, everything is good. Everyone's optimistic. It's usually you're starting a partner with a friend or a family member, and you don't think about things that could go wrong because you're focusing on how things can go right. But a real fleshed out partnership agreement that you really just do one time is very critical, because you can really dictate financial contributions or responsibilities and how you exit the business through this agreement. Because what happens is when the business evolves or you evolve as people and these issues occur, if there's no partnership agreement in place, then you come into an issue on how you're going to navigate the business. How are you going to navigate your own partnership without tying somebody to anything specific? Because the partnership is almost like a set of rules that you put in place so that when things happen, you can just go back to this agreement because you both agreed to it, or if you have multiple people. The most important thing to remember, and the most important mistake that business owners make, is not understanding that even though you don't have something in writing, thinking that that there's nothing that I want to say this. Let me just back up and say this. In Florida especially, there's default rules, and the rules say here's going to be the rule unless there's an agreement. So if you don't have an agreement, you do have essentially, and you do have rules that you have to abide by. It's just that your rules are the default rules of the state. So you could be violating the default rules of the state and not even know it if you don't have a partnership agreement. If you do have a partnership agreement, you're allowed to formulate your partnership that could be contrary to those rules, because now you're basically forming your own rules that you're playing by. And so that's what I want to emphasize here. The takeaway here is, if you have a partnership agreement, that's great because you have something that you and your partners can follow. If you don't have a partnership agreement in place, you're still playing by a set of rules that you may not even know about, which means that you could be violating rules that you don't know about. And if you have to go to an attorney, it could be too late. Are there any questions that I can address while we're on this topic of the partnership agreements, Allison?
Nope, you got them all.
Okay. So if you want to form a partnership agreement, here are some main points that you may want to think about, because these are the points that I see the most conflict in. So if you can address these points in your partnership agreement and get those fleshed out first, you can focus on your business so that when these issues come up under these points, you already have a way of dealing with it. And so these are the most important things. There are other things to address, but these 6 topics are the most important that I've seen. And by most important, I mean that when there isn't a partnership agreement in place or business partners are suing each other, they're usually suing each other over these issues. So let's go into the third mistake that business owners usually make: failing to separate your business and personal expenses. So the first point I want to make here is when you have a business, a lot of people choose the LLC because it's, there's that flexibility, but a lot of people are afraid of getting sued. So they think that if I just form my LLC, that I'm going to get all this liability protection and I'm never going to get sued in my individual name, because if anyone sues me, they're going to have to sue my LLC. That's not entirely correct. Forming your LLC with the state is the first step, but you have to operate like a company. If you want a court to treat your personal assets separately from your business assets, if you get sued, then while you're running your company, you have to make sure that you as a business owner are separating your business assets from your personal assets. If you convolute your business assets with your personal assets, then a court, if you ever get sued, is just going to treat that bank account as one and the same. So you're going to have to dip into your personal assets to pay for your business liabilities if you get sued. But it can also cause an IRS nightmare with your accounting and your taxes. So just really keep that in mind, that if you have a business, get a bank account in your own business, in your business's name. And if you have to, so if there's money flowing out of your business bank account, that needs to be documented on your business accounting software or your books as either compensation to you, or it could be a loan to you, but it needs to be documented. If you are putting personal assets into your business, I mean, whether it's cash or whatever it is, that needs to be documented as well. So if you are, let's just say if you're a business owner and you're having some hard times and you need to float payroll, so you are taking money out of your personal bank account to put into the business bank account, that needs to be articulated and fleshed out in your books as a loan to the business. If you don't do that, then it's what we call in the legal business, we call it commingling. And commingling is one of the ways that a business owner would get, we call it piercing the corporate veil. So it's one of the ways that a business can get pierced, meaning that the owner of the business would have to end up paying for the liability of the business through their own personal assets if the business can't cover the liability. Are there any questions on that, Allison?
Yeah, no questions on that.
Okay.
Thank you.
So this is what I was explaining. One way to really do this is really just, I have this couple of ways of just separating your finances. Because remember, the name of the game is whatever the business owns is in its own name. Whatever you own is in your own name, and you're keeping those separate. So you can get a business debit card or a business credit card. That should be in your own business's name, and you should only be using that for business expenses. Don't use your personal credit card to pay for business expenses, or don't use business expenses to pay for your personal expenses, your personal living. Don't do that. Pay yourself a salary. Make sure that that's coming from your business bank account. It's a good idea that when you're starting to make some money in your business and you are paying a salary, you get a payroll provider. You have them handle all of that and make sure that it's coming out of your business bank account. Keep your receipts and make sure that you have a record of those, so that if you are ever in court and there is a plaintiff, let's just say that you have $20,000 in your bank account, in your business bank account, and you get sued for $100,000. If you keep a record and you're showing everyone that you've kept all your business expenses as your business expenses, then even if you lose that lawsuit, even though you lost a $100,000 lawsuit, the plaintiff can only recover what is ever in your business bank account. So even if your business had $20,000 in the account and your personal account has $80,000, so combined you could satisfy that $100,000 judgment. If you do things the right way, then your business is going to be responsible for the $20,000, but then that plaintiff may not have anything else to recover because they can only recover what the business had. It doesn't matter what you had, and whatever you have in your personal account won't come into play. So the fourth mistake that business owners make is not having a tax strategy. And I have this pro tip in here that a tax strategist is different from a CPA. A CPA is designed to protect the public from you as a business owner. The CPA is making sure that you are complying with the rules of the IRS, and the CPA is making sure that you have clean records and making sure that you're not going to get audited by the IRS. But not all CPAs are tax strategists. A tax strategist, their job is specifically to help you save money in a legal way. So working with a tax strategist or a tax attorney, sometimes they're one and the same, but working with them at the very beginning helps you set up your business in a way that you as a business owner can maximize your tax savings. Not doing that has you playing catch up. It has you, what happens is if you're not using a tax strategist and you're not using CPA, ideally you want to use both of them together. But if you're not using them, what happens is you're just focusing on making money, and then you get to a level where either you get audited or maybe you get an investment, or maybe you have to sell your business, and there's all these issues that are coming up on your books from decisions that you made years ago that you're now having to clean up. When you have a tax strategy and a CPA together, not only are you get peace of mind to know that you're following the rules, but you also are understanding that your business is setting up to maximize the amount of money that you get to take home at the end of the day. So when you're considering your tax strategy, one of the things that you want to consider is your tax election that we discussed earlier. If you're going to be an LLC, you have options. Are you going to be an S Corp? Are you going to be a C Corp? Or are you going to be a partnership? If you're by yourself as an LLC, then you don't have the partnership option, but you still have the C Corp or the S Corp election if you want it. So you want to make sure you understand that your election is going to dictate that all these things going forward. And sometimes, as a business owner, you may change your mind. You may decide that you start out as an S Corp and maybe you want to be a C Corp down the road, or a C Corp and S Corp. You want to understand the implications of that and how to navigate your path going forward with your new tax election, your new tax strategy. Because at the end of the day, you're in this to make money. And if you find yourself constantly in positions where you're dealing with the IRS, getting audited, or you feel like you're just paying too much in taxes as a business owner, it's a very frustrating thing to have to go through. So it's best to be proactive about this so you don't have to worry about that down the road. Any questions before we move on to our next mistake?
I do have a question. How do we find a tax strategist?
So that is a good question, because I don't believe that there's a lot out there. If you just Google tax strategist, when I refer my clients to tax strategists, there's one I have in mind, but just and this blows my mind as a business owner myself. I think there's not a lot out there, because the one person that I usually go to refer my clients to, they have a waiting list of over a year. So to me, that means that there's this huge demand for them, but there's not enough. So I believe there's associations of tax strategists. So I would just start with Google tax strategists. There are some firms that will come up. There are some that are lawyers, and start there. When you are interviewing, you can also interview a CPA and ask them, are you a tax strategist? That's also a good way of going, but that's what I would do. Start there, Google tax strategist near me, see what comes up, look at the websites, and if you don't see tax strategists on their website, call them for an appointment. And when you're interviewing them, ask them if they are a tax strategist. If they don't know the difference between being a CPA and a tax strategist, that's your indication right there. But that should be a good start to help you find that.
Thank you.
All right. Let's move on to intellectual property. So a big mistake here is not protecting your intellectual property. You may be familiar with patents, trademarks, copyrights. All these things help develop your business. They help build your brand. These are things that are creative. These are legal protections for the creative process of being a business. A business is, in my mind, a creative machine because you are providing your value to society in a way that another business cannot. And your ability to capture the things that make you unique through the use of patents, if you're inventing something, trademark, if you have a unique name or a brand or copyright, if you're writing certain things, all these different things should be protected because it adds value to your business. But most importantly, it gives you legal security to help you fight people who are stealing your property from you. And so when you're coming to an attorney and you're saying that this person is using my name, or they're using a photo that I created, or they're using my stuff, and you don't have a patent, a registered patent, you don't have a trademark, you don't have a registered copyright, it makes it harder for the attorney to represent you, because you're going to face an uphill battle. When you have these things in place and you're registering them, then it makes it easier to go after the people who are stealing your intellectual property, because the court system does a good job, in my opinion, of penalizing people who steal intellectual property. The penalties are very harsh. But you only get the benefit of these if you're showing the world that you are actually protecting your property. So here's a few ways of safeguarding your intellectual property, because again, the point of safeguarding your creations is so that if you have to go to court, you're showing the judge that I've done whatever I can to protect myself. Now I need you to punish the other side so that I can be made whole. And so the first way to protect yourself is to actually use your intellectual property. So it's not enough that if you get a trademark in your business's name and a copyright, that's great. But if you're not using it, you may end up losing that protection. So make sure you're doing that. You're using your actual property. You're registering it. So if you are starting out, and let's just say you have a side hustle or something like that, and you're using this brand name, and you're seeing that it's actually becoming popular, you want to protect it, well, you go take the next step, register your business, register these things so that you have a record of these official government entities that are recognizing your business, they're recognizing your intellectual property. Because what that does also is it makes it public. And so that if somebody's using your intellectual property, you can show that you've done your steps to making what you've done public, so that there's no reason why they should not have known that they're stepping on someone else's property. The use of non-disclosure agreements, these are NDAs. We're going to those a little bit later, but using these NDAs and licensing contracts for your employees and your partners are ways to help you do that, because you're putting them on notice that they're going to be getting exposure to your intellectual property. And here's how we're recognizing how to handle it. You're going to recognize that this is my property, it's not yours. If you have to leave my business, if our relationship ends, here's the protocols on how we're going to handle it. And you're always making sure that they understand that if they were to violate these agreements, there's going to be heavy penalties. So it's a great deterrent from having former employees former partners or service providers take your property from you. And you can also implement security measures internally. So these aren't legal processes, but what they are internal processes that you're taking to make sure that your property is protected. An example I like to give is Coca-Cola. You know, Coca-Cola has the ingredients of Coke is secret. So what they do is they have their own internal processes of making sure that the ingredients to Coca-Cola are only available to a very select group of people. So this kind of goes hand in hand, is that a business mistake that you can make is not just failing to protect your intellectual property, but a big mistake is infringing on someone else's trademarks. I specifically say trademarks here because the rules of, or at least the penalties of violating a trademark, if you were to go to the process of getting a demand letter for somebody else and somebody saying that you're violating my trademark, and you actually did violate it and you didn't make any steps to correct it, and they sue you and you lose, not only can you be liable for the damages of what they can articulate is what they say is consequential damages. Because what happens is that if you violate someone's trademark, they're going to say that we lost X amount of business because of your infringement. So you're going to be responsible for basically almost reimbursing or paying the damages of that company for the profits they lost. But what can happen is you may actually have to end up paying a portion of the profits you gained to that person whose trademark that you're infringed on. So it's a double whammy there. So you want to really make sure that when you're starting out and you have an idea, take a first step of actually just Googling it, whether it's a name, it's an image, searching the trademark database, searching the state database to see if it's possible that that your idea could have already been thought of by somebody else. Google is a very helpful, powerful tool in that, because that simple step can really help prevent these issues. Because one of the worst things that can happen to you is you get sued for a trademark infringement and you have to pay a cut of your profits that's a whole other business. That could really just tank your business. Because as I said, do your research. What I've seen before, so trademarks don't expire. So what I've seen before is people will come to me and they say, I'm aware that this other business is using this name that I want to use now, but they're not doing anything. They're not active on social media. In fact, I think they closed the business. So I should be okay because I think the business is closed. Trademarks don't expire. So as long as if you have a trademark, as long as you're paying the filing fees every few years, your trademark is being renewed. And so even if you close down your business, it's a gray area here, but it could be possible that even if you're not active with the business, but you still are keeping up with the trademark, that trademark could still be active, so that it's faulty thinking to believe that just because a business is not necessarily active with their trademark, that trademark is up for grabs. That's not always the case. So again, search the trademark database, just Google USPTO, and they have a tool, they have a lot of resources to help you search that. So just to make sure you understand what's out there so that you can at least be aware of a possibility of infringing on trademarks. Do you have any questions before we move on?
Yes, I do have a few questions. Okay. What if someone registers your company name as a trademark after you've registered your company? What do you do? And is that something that can happen?
I'm sorry?
And is that something that can happen?
Yeah, so if somebody registers,
what if someone registers your company name as a trademark after you've registered your company?
Okay, yeah, so that can happen. So if you register your company name first, and then someone registers your company name as a trademark after that, right? That's the question, right? I just want to make sure I got that straight. Do I have that correct, Allison?
Yes.
Okay. So in that scenario, I'm assuming that the other person actually got the trademark approved, because there's a difference between filing for a trademark and actually getting it approved. So if it was actually approved, then unfortunately that person does have the best legal position for that trademark. So when we work with clients, we usually do it in a hand-in-hand process. We will have them check the trademark database first, and if the name itself is that important to their business, then we actually have them consider filing for a trademark at the same time they file their business, because something like that can happen. Now, it doesn't mean that in this scenario that you're just, there's no hope. What's important here is if you can demonstrate that you've used your trademark first before the other company registered theirs, then that other company may not be able to go after you. Now, that other company could go after other people, but they may not be able to go after you. So there is an element of a little bit of protection there, because you can demonstrate that you have that registration first, but you would have to really, really, really emphasize that you were actually doing business and actually engaging and using the trademark. It wouldn't be enough for you to just say, I registered it with the state of Florida.
Okay. Well, actually, that last sentence, you just answered the next question that I have. I have two people here that have asked, when you register with the state, is that validation enough? And is registering your business with the state sufficient for protecting your name and intellectual property?
So registering when it comes to Florida, registering your name with the state of Florida is sufficient to protect your name, because Florida does not allow businesses to use the same name if it's a legal name. If you're registering your name as a DBA alone, that's not enough. That's not going to be protection, because if you just register your name as a DBA, Florida does allow DBA, another business, to use the exact same DBA. You can do that. So that's not enough. Now, you could get a Florida trademark instead of a federal trademark, because they're cheaper and faster to get. But if the ultimate question is, if I just register the name with the state, is that enough to protect the name and to the intellectual property? Unfortunately, that won't be enough. So if I go back to how important is the name to your business? If the name is extremely important to how you do business, you need to consider getting a trademark in conjunction with registering the name. If it's not, like if you just have a holding company for real estate where it doesn't really matter, then you don't really necessarily need to worry about getting a trademark, because your name itself is essential to your business.
Got it. Thank you so much for that. I do have one more question about trademark and registered trademark. I know that there are some companies that just use TM, like for example, Starbucks, but that isn't technically a registered trademark, correct? So
that's correct.
I guess so. Why would a company as large as like someone like Starbucks, and I've seen it with a few other large companies, why wouldn't they just register it?
So I can't tell you as to why they won't do it. I can tell you a practical reason.
What are the benefits to not register?
So I'm gonna say, what I'm gonna say is that there's no benefits to not registering. You can only benefit from registering. Now, what happens is that, without getting too technical, in a legal world, there's something called a common law trademark, which means that as soon as I create something, I technically have a legal trademark. So let's just use Starbucks for an example. If the moment Starbucks created their logo and the name, and let's just say they slapped on that TM. So they got somebody, so they created the logo, and then they put the TM on there, and then they just went out and did business. They do have a trademark on that. Even if they don't register that, because a trademark is created as soon as you create something. The benefit of registering is that if back when the creators of Starbucks. So let's just say that somebody a month before Starbucks created their logo actually registered that trademark, the exact same trademark, and they actually got it registered. And Starbucks just continued to use the TM. That person who registered could sue Starbucks for trademark infringement because that registration gives you that strongest protection. But you don't have to register it to have protection. So if I were to go out tomorrow and create a logo that's just like Starbucks, Starbucks can still go after me because Starbucks has established enough of a record of showing that they use this trademark, even though it's not registered, to still get that protection. So as a business decision, I can't tell you as to why Starbucks hasn't registered their trademark. What I can tell you is that the registration process is a pain in the butt because it can take, if everything goes right, it can take a year to register, to go from starting the application process to getting the actual registration to where you can put the R instead of the TM. So as a little aside, sometimes you see an R, sometimes you see a TM. TM means the trademark isn't registered. R means the trademark is registered. But that can take a long time, and there's a lot of back and forth. It can be expensive. So that could be a reason why, but a company as big as Starbucks could afford it. But I mean, maybe it's just not practical because their common law trademark is strong enough. As a small business owner, you may not want to take that gamble. You may want, especially if it's important to you, you may want to just go out and register it right away instead of doing what Starbucks did. Even though it's worked for them, it doesn't mean it's going to work for everybody.
Thank you for that explanation. And I do have more questions, but please, I guess, go forward with your presentation. I can ask more later.
Okay. Yeah, I mean, I'm happy to answer questions. I just wanted to be mindful. I know we're all busy, so I didn't want to take away from everybody else's day, but I'm happy to answer the questions.
Okay. All right. Let's see. Okay. Thank you so much for the wealth of information for asset protection. Actually, here's a question. For asset protection, do you recommend having an invocable trust that wraps around the LLC? Actually, this is a few questions. And do you recommend having more than one LLC for your business? For example, a public facing that we advertise and one other LLC that holds equipment and other assets for better protection.
Okay. So yeah, so it's definitely a loaded question. So what I would say, I'm going to keep this in the context of asset protection because there's tax considerations, operational considerations for all of that. So let's keep it focused on asset protection. So for asset protection purposes, a trust does not give you asset protection. By having a trust, you don't have asset protection. What a trust gives you is privacy. Now, if you want to consider privacy as a form of asset protection, maybe you can because when you form a trust, you don't have to file that with any state agency. It won't pull up in any databases. So if your objective is asset protection and you think that the best way to do that is to have an LLC wrapped in a trust, what I think you mean is you're saying that you have an LLC and the owner is a trust. So the owner of the LLC is a trust. It is a way to think about asset protection because your individual name won't appear on the state database. So if you didn't have a trust and you were the owner of the LLC, then your name would appear on the state database so that if anyone were to sue you and they did an asset search for you, your name would pull. If you had a trust, your name wouldn't pull. So in that context, it does provide you that. But to me, when I think about asset protection, I think about liability protection. And a trust in and of itself does not provide you liability protection. To me, I just see it as a better way of just providing more privacy for you. To the second question about having multiple LLCs, a public-facing LLC, and then an LLC kind of doing work behind the scenes, that is a good way to look at certain things. As long as, so from an asset protection standpoint, and I would look at that as what you're basically, if you're looking at it as, how can I make sure that the assets of LLC 1 is never affected by the business of LLC 2, then the separation of that is a great way to do that. You have those two LLCs. When you do something like that, though, especially if both LLCs are owned by the same people, you have to really treat them as different. So you can't have two LLCs in that situation and doing things like that, but have one business bank account. Each LLC has to have its own business bank account. And if the LLCs are doing business with each other, there needs to be contracts between the LLCs. Even if it sounds stupid or looks stupid, by you signing the contract on both sides of the equation because you own, you're the single owner of each LLC, you still need to do that because you're treating them differently. So again, the rule is if you want a court to treat your LLCs differently as far as asset protection goes, then you have to treat them differently when you're operating them.
Okay, thank you. Yeah, I do have more questions, but they are about other things.
Okay.
Yeah.
So what I'll do is I'll just move through the presentation. I think we're on 8, and then I'll just address the other questions as a whole at the end of the
Okay, wonderful.
Okay, perfect. Okay, we're on 7. Okay, yeah. So speaking of contracts, not having these contracts in place is a huge mistake. So I group this mistake in like 2 buckets. There are business owners who decide to not use contracts. I say 3 buckets. Business owners who decide to not use contracts and they'll just do handshake deals or verbal agreements, which, by the way, verbal agreements are contracts. So be careful about that. Then there's the business owners who say that I'm going to just write my own contracts, or I'll just I'll Google contracts and then I'll just write them myself. And then there's the business owners who say, well, let me just use a service like LegalZoom, and I'll have them write my contracts. So in the order of mistakes, of like severity of mistakes, 1 is not having any contracts, 2 is doing it on your own, and then 3 is using LegalZoom. So LegalZoom is better than doing it on your own, but there's faults with all 3 of these. Mainly in that if you were to work with an attorney, the attorney has a deep understanding of how, if you're working with a business attorney, the business attorney has an understanding of your business as a business. They understand the risks that your individual business has, because in working with the attorney, you're going to explain how you do business. Then the attorney is going to analyze, well, the way that you operate your business, here's the risks. So now let's use these contracts to anticipate those risks and deal with them. When you're doing these things, whether it's LegalZoom on your own or not having them, you're not having that conversation. So your contract is not anticipating these things. When you're doing it on your own and using LegalZoom, you're just going to be having these general provisions in there, and they're not going to appreciate the way that you do business. And also, the main benefit of using an attorney is the attorney can put things in the contract that LegalZoom doesn't do at all. So I've actually gone through the exercise of going through LegalZoom and seeing what they actually put in contracts. And there are certain provisions in those contracts, or there's certain things that I know that I could put in those contracts. Excuse me 1 second, I just need to put my battery in. Okay. I'm sorry. So there's certain provisions that can go in those contracts. They can double your protection. And I'll give you an example. One of those things is an attorney's fee provision. An attorney's fee provision, if you have a contract that has that in there, and if it's structured the correct way, if you have to sue somebody, not only will you get your money back if you win a lawsuit, but that person who loses the lawsuit has to also pay your attorney's fees. So you actually are put in a whole position, as opposed to having to sue somebody, spend money on an attorney, and get your recovery, but you come out at a net loss because you had to pay your attorney to get your recovery. So not using contracts, not using an attorney is a huge mistake, because once a problem happens and you don't have a contract, it's too late. Now you're digging yourself, now you're in a hole that's going to be way more expensive for you to dig yourself out of. So here's some examples of just some ideas of what are some provisions that are in a rock solid contract, I believe. If you're at the level where you can't afford an attorney, or you're just starting, at the very least, use LegalZoom, and then make sure that these things are addressed in there, because these are powerful provisions that will help protect you if you ever have a problem, which is the whole point of a contract to begin with. So you always want to keep that in mind. But here's just some things that can kind of start you off with, making sure that you have in your contracts. You have any questions on that, Allison?
Let me see here on this specific thing. Not on this specific topic, but I do have lots of other questions.
Okay, all right. So I'll just keep moving then.
Okay.
And then we'll address those at the end. So, all right. So mistake number 8, as someone mentioned, NDAs. So NDAs are not called non-disclosure agreements. They can be called confidentiality agreements. They have different names, but the main purpose of these is to recognize that you as a business have intellectual property, as we discussed earlier. You have intellectual property that you're going to be engaging with another person, to where that other person may be exposed to your intellectual property. So you want to have a contract that puts obligations on the other side on how they're going to handle the information, making sure that the information is kept confidential, and it also governs what happens when that person leaves, whether it's a relationship or your employment. So the benefit of the NDA is that you have this contract. It can prove to be it can serve as a deterrent for, especially for employees who are in, a lot of people here are in service-oriented businesses. So a big issue that we have is you see that if you have an employee and they start learning your trade, they start learning your secret sauce, you want to make sure that if they leave you, that they can't use this information that they gained to your disadvantage going forward.
Okay.
So these, and this, I mentioned that there can be named, they can go by different names. So this is something that early in my career I had to navigate myself. That it will trip me up, so I can understand if it trips up any other business owner. That an NDA can also be called a confidentiality agreement, or a confidential disclosure agreement, proprietary information agreement, secrecy agreement. If you see those names out there, just understand that it's basically the same thing as what I'm talking about here. Is you're mainly using these agreements to protect intellectual property that you have, that you understand that someone else is going to be exposed to, and you want to make sure that you protect that information while they have the relationship with you, and after they leave you, after that relationship is severed. And also the tangible benefit is that, let's just say that you need to sue someone for infringement on IP. This is a document, this NDA is a document that you can use to prove that you're taking the steps to protect your intellectual property. So there's also a tangible benefit to using that as well.
Okay.
Do you have any questions, Allison?
I do have some questions. Okay, so you've already you spoke on NDAs already. Let's see here. Is copyright more advantageous or patent for business name or logo of the business? What do you think?
So, I'm not quite sure what you mean by advantageous. If you're saying that by advantageous, what offers more protection? There's usually a different process. So patents are, if you look at everything as IP, the patent and the copyright are two forms of IP. Copyrights are two forms of IP protection. So copyrights are meant to protect written or literary artistic words. Like if you are doing an audio book, a textbook, like song lyrics, like those are written words are used for copyrights. Patents are used for inventions. These are products, or these are physical things that have been invented, or a specific process of inventing something that's unique. So I look at it as you get the same protection from a copyright, a patent, or a trademark. It's just a matter of they protect different things. So I think that's the distinction that I want to emphasize there.
Okay.
Now, what I will say is that the processes are different. Some are easier, some are more expensive, some are easier to protect. Copyrights are maybe harder to protect than patents. Patents may be more valuable to have because investors love them, they look for them, they be more lucrative. But at the end of the day, there are just three different ways to protect different types of intellectual property.
Okay, thank you so much for clarifying that. This looks more like a statement instead of a question, but it says the jury trial waiver is critical from the employee's perspective and no attorney's fees from a business vantage point as a principal. I guess, could you speak on that? It's not quite a question.
So what I would say is the jury trial waiver. I'm looking at this from a business lawyer's perspective. So my job is to protect my clients. My clients are businesses. So these last 2 points is the attorney's fee provision and the jury trial waiver. Let's talk about jury trial waiver. So if you were to sue somebody in any context, you have a choice. Do you want a bench trial, which means is a judge going to determine the winner and the loser, or a jury trial? A jury trial is a group of individuals who are going to determine the winner and the loser. So what I tell businesses is, especially if you have a sophisticated business, there's a lot of money at stake, do you want a group of people whose only qualification to be on your jury is that they had a valid driver's license to determine the outcome of your legal issue? Or would you feel more comfortable if something went wrong that a more sophisticated, or by sophistication I just mean someone who's trained to understand legal concepts, a judge? So from a business lawyer perspective, I prefer my clients want a judge. So what you have to do in order to ensure that is you draft a contract that has a jury trial waiver. That means that the other side signing is recognizing that if anything happens to us and I have to sue you, I am agreeing to waive my right to a jury trial. So you're basically, it's a way for a business to always ensure that there's ever any litigation that it's going to go to a bench trial and not a jury trial, because juries it's a group of individuals, and to me, it's more of a crapshoot on what's going to happen. A bench trial it's more sophisticated, it's more organized, and as an attorney, you can feel more comfortable arguing your case in front of a judge because the outcomes become more predictable. And the attorney's fee provision is advantageous from the business perspective as well. So I think the comment was just mainly focusing on, if you're an individual, you may not want a jury trial waiver in a contract that you sign, and you may not want an attorney's fee provision in the contract that you sign. But as a business, you do want those two things in there.
Okay, thank you so much. We have about 20 minutes left. Okay. Is it best to have an NDA for employees when hiring, or is it determined by the nature of the business?
Yeah, so what I would say is the nature of the business and nature of the employees. So if you are it depends on how the employee, what the nature of the information that the employee is going to handle. So like if I were to say that I wouldn't give an NDA to a janitor. I would give an NDA to a janitor if I run a restaurant. I would give an NDA to a janitor. I may give an NDA to a janitor if I am a doctor's office that has patient records in offices that I know the janitor may have access to. So it depends on the nature of your business, the nature of the information, and the exposure to that information that the individual employee will have. And so ultimately, don't give NDAs to everybody. Not everyone needs NDAs. Not all businesses need NDAs in every context.
Got it. Thank you so much. Just a few compliments. Well said, Attorney Bryant. Um, Thank you so much for all of this wonderful information. And actually, those are all the questions that I have. So we have about 20 minutes left. Is there
Okay.
anything that you would like to share? How to contact you, or even share a story where someone hiring a business attorney really saved them some money? If you could
Yeah,
go.
so if you want to contact me, the best ways, I believe, Allison, you put it in the chat, is you can email me at info@sbttlaw.com. Just what I will say is, the employee documentation is the ninth mistake. The 10th mistake is just not engaging a business attorney. So what I will say is that the we have my law firm has two arms. We have the proactive arm. These are clients who come to us before issues arise. So these are clients who come to us to start a business, to create a contract, to form a partnership agreement. Then you have the arm that's the reactive part. These are clients who are coming to us because there's a problem. They're getting sued, they want to sue somebody, they signed a contract, they understand it, that kind of thing. The people who spend the most money are the people who come to our reactive arm. Those are people reacting to issues. The people who end up getting the most benefit are the people who are on the proactive side. And so, if I could think of an example, yeah. So I could an example that I have is had a client came to me. He's on the proactive side. Comes to me. He's starting this. He has a startup, and I had to, in a general sense, I can't divulge too much, but basically, he has a way of changing. It's a startup in the medical industry, and he's by himself, and he's very smart. He has a PhD, very well educated, but doesn't know a single thing about business. Knows he wants to have investors, so he engages with us at the very beginning. And what we do, or I'm sorry, he engages with us after he formed an LLC, and he was trying to raise money, and then he engaged with us when he started getting interest because he got nervous because of the money that he's trying to raise. So when we came in, we helped him understand that we started from the very beginning. One, your entity structure is wrong. We need to reform it. We need to reform your entity structure. We need to change it into a C corp. But now, because you've already started doing business as an LLC, we have to just make sure we make that smooth, because you're about to go into and you're about to have these investors. So we help him do that. Then when the investors come into play, he's having us help him do the due diligence and help him meet with the investors. What this is doing is now he's having us kind of do this stuff in the background while he's helping grow his business. If he didn't have us, if he didn't have even if it was another attorney, what he would have done is he would have went into this LLC with this LLC, tried to recruit investors, and they would have said yes, they love the concept, but then they would have saw red flags because he's got the wrong entity type, and then now you'd have to negotiate with them for millions of dollars, but he's going to have tax issues because his structure wasn't correct. So by having us at the very beginning, it helped him save thousands and thousands of dollars and helped him secure these investments because we anticipated these problems before they arose, which means because the problems would have arisen as soon as the investors would have given him the money. So we kind of helped him kind of solve those issues way before they would have become a huge issue or a huge problem. But thank you guys for having me. And that's all I got. So Allison, I think I'll just turn it back over to you.
All right, wonderful. Okay. All right. Let's see here. If you open an LLC in one state and work your business in another state or throughout the United States, is it best to get a trademark? And does the LLC registration in one state cross over to others?
So I'll answer the second question first. The LLC registration is only for the state. So think of LLC registrations as a state-based thing. Now, it doesn't mean that you don't have an LLC in other states. What happened, the rule is, if you're doing business let's just say you start off your business in Florida, and let's just say you move to Georgia, and you're doing business in Texas. The rule is you have to register your company in every state that you're doing business in. So what would happen is you already have the Florida registration. You would be registering in Texas. You would register your LLC as a foreign company in Texas. You could be living at home, but you could be living in Georgia. But if you're quote unquote doing business, and the definition of doing business is very flexible, it's very, in this day and age, it's very touch and go. So you may want to register your business in Georgia to be safe, but maybe you have an argument that somehow you're doing business in Texas without, without being there. But the point is that you have to be registered in the business in the states that you're doing business, and it's just an extra filing. For trademark purposes, in that scenario, a federal trademark is most appropriate for the name. So if you're using a name that's very important to your business, then you would want to register the trademark, because registering a trademark means that everyone's going to recognize it across the country. I hope that answered the questions.
It was really helpful. If not, you can please just add another question or comment, and I will ensure that we get you an answer. Oh, I have a message here. Can you please elaborate a little more on slide 9 and 10?
Okay, so I'm assuming like mistake 9 and mistake 10, not the actual slide 9 and slide 10, or
Yes.
Mistake 9 and mistake 10?
Yes, mistake 9 and mistake 10.
Okay, so yeah, so for employees, when you're hiring employees and you don't document your system and your process of hiring employees, you can run into big issues with the state. So one of the biggest issues that we've seen is basically having 1099 independent contractors claiming that they're W-2 employees. That can cause huge issues. So having employee documentation, documenting that process, having offer letters, making sure that you have a payroll processor that's determining how much tax to withhold, using your non-compete agreements. All these type of things are ways that you can identify the people working for you as either an employee or an independent contractor. So I think that's what, and I should have said that earlier, so thank you for bringing me back to this. But the 1099, versus the W-2 distinction is extremely important. But we've seen it. We've seen people have contracts with 1099s, and the 1099s, what will happen is they stop working for the business, and then they'll try to file unemployment, or they'll try to file for, there's another thing they can file for, but they basically go to the Department of Labor, and they claim that you as a business are treating them as a W-2 employee, meaning that you should have been withholding their taxes and you should have been paying self-employment taxes on them, but you characterize them as a 1099. So you're characterizing them as a 1099, but treating them as a W-2 employee, which is a big no-no, and that can happen. So when you have this employment documentation in there, if the Department of Labor comes to you and says that we have this person doing this, you're claiming that they should have been treated as a W-2, you have everything in place. Or if you have W-2 employees, you want to make sure that that you verify their eligibility, that you're taking out the correct taxes, and that you're keeping track of their hours, so that if you're paying overtime, that's documented, or if you don't pay overtime, you make sure it's documented, because those are issues that come up with your W-2 employees. So that's the crux and the big takeaway here from employment documentation. For just engaging a business attorney is kind of what I've alluded to, is that the main thing here is that if you're working with a business attorney, your major hurdle is thinking it's expensive and I don't have the money right now, I'll do it later. But then what happens is a problem will come up, and then you need an attorney, and then you find out how expensive it is to solve your problem or to clean up your problem, as opposed to coming to the attorney before you have a problem. Coming to an attorney coming to an attorney before you have a problem is 10 times cheaper than coming to an attorney when you have a problem. And that's what the main takeaway there is.
Got it. Wonderful. Well, actually, those are all the questions that I have. I've got lots of thank you. Thank you so much. Great information. Thank you for sharing. Can SAM help businesses that are not registered or located in Florida?
So it's a limitation for us. It would depend on what you want us to do, but we are Florida licensed attorneys. So I would say, for an example, if you need us to draft a contract for you, the contracts that we draft are drafted based off of the laws in Florida. So we will not be able to draft contracts for you that are based in other states. But if you're located in another state, as long as you're doing business in Florida or you want a contract that's based in Florida, that's how we can help. Otherwise, your best bet is speaking to an attorney located within your state.
All right, thank you so much. Oh, thank you so much for your valuable information and willingness to share it. Definitely appreciate the presentation. Thank you so much. Thank you so much for joining us, everyone. Well, that is actually all I have. Sam, do you have anything else to add?
I don't. Thank you all for your time. I know, it's hour and a half of your time, so I really appreciate it. For those of you listening later, the fact that you're listening to this presentation actually puts you way ahead of a lot of other business owners, because you're curious enough to think about these mistakes, and you can do something about them now if you've identified that you've made any of them. So kudos to you. That's very important to know.
Wonderful. Thank you again. Thank you so much for joining us. And just so you know, everyone, all of you who have registered for this webinar, you've all been added to my email list to learn about upcoming webinars. And if you are registered for this webinar, give me a couple of days. I will send out a webinar replay along with the presentation slides so that you can watch it at your leisure. And please do not forget to register for our small business, my small business website, because we've got lots of stuff on there that can really assist you with any of your business needs. And again, thank you so much for joining us, and thank you so much, Sam. I really appreciate you talking to us today.
No, thank you for having me. It was a pleasure.
All right, bye everyone, and have a wonderful week and a wonderful weekend. Take care.